Happy birthday, MYCO. Hi, guys. It's Bill Henderson. I hope you're doing well. So, it's MYCO's birthday, and we see MYCO everywhere in this court community. He's in all the channels, mostly a mod, screwing it up apparently, but that's okay. Um, he does a lot to make sure that we have good content, to make sure that the channels run smoothly. And, you know, wish I could give him more than a clip for his birthday, but this is what he gets. And this is not a full trial. We're not going to see the whole thing. I understand to a lot of you the content of this particular hearing might be very interesting to you. I'm not playing it, and you can go read about it in the newspaper like everybody else. We're here to see the judge. The judge is fantastic. So we're just going to listen to the judge for 14, 15 minutes. We're not going to see the end. We're not going to see the decisions or anything. We're just going to see a good Southern Georgian judge. And then we're going to go back to Kim Hurd. And this is for MYCO.
After January 3rd that we responded to. They were sent even after our deadline to produce documents. There were ones that we responded to once Your Honor signed the confidentiality and protective order that allowed us to unseal documents that had been requested. We couldn't even open them until that day, which we immediately opened. I was actually at my courthouse anticipating Your Honor signing it. We opened them right then and began copying them. Those were all produced last Thursday, Friday. These are the records that we've been contacted about last night and this morning, saying that there were specific voters that were not found. We're trying to track them down and provide them. My elections director is here with me. I'm here. Neither one of us are in the office to actually do that, though. So, Your Honor, as I stated, McDuffie County, we don't oppose this request. We do join in it. I just wanted to let the court know this information, and if we go forward with those 9.
Fine. This is for MYCO and Miguel. Happy birthday, Miguel. Happy birthday.
We have not had the opportunity to investigate, and we won't have any information if there is any to share with the court parties on those 9. Thank you, Your Honor.
You have anything?
I do, Judge, very quickly. First, Mr. Dunaway and McDuffie County have done an unbelievable job. I just want to acknowledge that to the court. The focus of this case is going to be McDuffie County. There's a couple of other issues in Warren, a couple in Glasscock. It is somewhat unpredictable to me that Mr. Moses would so vehemently oppose us going forward today, because I don't think any of his 3 counties are primarily at issue here. The reality, Judge, is if we're talking about a 1-day continuance, could we be willing to work with that? Sure. If we're saying, hey, come back tomorrow, we can't be having multiple week continuances. And the only way that we would agree to a continuance is if Mr. Sparks made the stipulation that he was not going to pursue any legislative stay. What we're trying to do is, obviously, my client is incurring a lot of money. Having an expert here today, having me here, having all the witnesses here, we operated under the schedule that this court set, that these council agreed to. And nothing was said until 9:02 p.m. on Friday night, when everything had been set in stone. I frankly think, just on the basis of the lack of timeliness alone, warrants a denial of almost any continuance. They've had just as much time to prepare their defense as we have. And you can't just throw out an open records request and say, hey, I requested every ballot, I requested every voter document that exists. They haven't given it to me yet, therefore we need a continuance. If you hadn't got the documents, you got to press to get the documents. That's what we've been doing. As Mr. Dunaway said, there are 4, as we continue to go through the documents and pull out the ones that are relevant, there are 4 we haven't gotten, and we do need those documents. These documents were requested back in December. Again, McDuffie has done Herculean efforts, and in no way am I criticizing them. I'm just saying, you know, it is what it is, but we have to operate with utmost expedition. This case is being followed by the media. This is being followed by a lot of individuals and people. The evidence is going to show this election was not properly done, and we need it to be done as promptly as possible. So I would respectfully submit to the court, we do not think a continuance is proper for all the reasons I've already said. Georgia law clearly says they must be done with utmost expedition. Very few of the issues, some of the issues, not many, are with Mr. Moses' clients. Again, I don't know why he's so vehemently against it, us continuing today. Maybe there's other reasons I'm not aware of. But for purposes of today, we're ready to go. If there is any continuance, it needs to be very, very short. And I mean 1 or 2 days. If they need to get an expert here and they need 1 or 2 days, or we need to get the documents 1 or 2 days, that it really should not be more than that. I mean, I very strongly believe that, and we will only stipulate to a continuance or agree to a continuance if Mr. Sparks agrees not to exercise any legislative say.
Like the 2 voters who voted in Warren who should not have.
You
Don't worry. The lawyers are talking. We can't hear them really well, but we don't need to. We want to hear this judge. And here he goes.
contend Warren's got some others that should have or should not have?
There may be a couple, Judge.
But I want to say the court appreciates and I understand there's a difference between having 10 and 29 and 40 something to get to check on. Okay. It's interesting. If you think about this now, just think about this. You have an election, what is it, the second Tuesday in November?
First Tuesday.
First Tuesday?
Tuesday after the first Monday.
Okay, Tuesday after the first Monday, okay. And the session begins at what?
I'm sorry, the session ends.
The session.
40 legislative days begin the second Monday of January. Ordinarily, that leads to an ending
So-
at the end of March to mid-April.
So we're talking about 60 days, give. Do you really think the legislature contemplated getting all this done through the holiday season? I mean, come on. With all apologies to the legislature, I don't know what they consider sometimes. But there's no way that you could force people to litigate during the holiday season. They've got vacations planned, they've got leave of court, the lawyers do. Finding a judge is not easy. You got witnesses that, quite frankly, they don't want to be up here. They want to be celebrating Hanukkah or Christmas or some other time of the year. Thanksgiving, that everybody celebrates. It's nuts. Why don't they have elections in July? Then you got 6 months. Generally, county commissioners, sheriffs, city commissioners, they take office the first of the year. Have them all in July or August and give people 4 months to get these things straightened out. Now, as far as the legislative thing, this court does not necessarily believe that applies to this case. If you apply it to this case, the next time that there's a challenge to a person going into the legislature, there's going to be a motion to stay that person's swearing in. Do you not agree that's what would be the next step? If that does in fact apply, some lawyer is going to say, look, illegally elected, ask you to stay. And some judge somewhere will grant the stay. They do it with city councilmen all the time. And I understand But there are occasions on which shall is not interpreted as must. One, for example, is that when you qualify to be sheriff, at least in Muskogee County, you shall get fingerprinted before, within the first 3 days after you qualify. You shall. A woman running was the deputy sheriff. She shall get fingerprinted. The person that takes fingerprints in Muskogee County at the time was the probate judge, a person in the probate judge's office, and the probate judge let that person go at 4 o'clock on the third day when it was supposed to be 5 o'clock. Shall was not interpreted as must in that case. Did everything she could to comply. She went in the next morning at 8 o'clock and got fingerprinted. That's close enough. Shall don't necessarily mean must. Granted, much of the time it does, but not all the time. I know about that case because I'm the one that said that's close enough. No, sir. I'm just telling you. If I were the judge and somebody moved to stay, I'd grant it. I have a case in the Supreme Court right now that it took the city, it's a Waycross case if you want to look it up. It took us about 7 months to get it done. And so that person served for 7 months on the city council. And when they appealed, he's still serving, which is fine. And they probably will reverse it, you understand? But that doesn't do the part about expedited any good. I do say that this makes it that having multiple counties involved makes it very difficult. This court would suggest to you that the legislature never contemplated the differences. It's not like basically Cobb County, which would have probably several different districts within one county, or Fulton. But down in the hinterlands where I live and where y'all live, the truth is what's good for Fulton County and Cobb County ain't necessarily good for what's in Washington County and McDuffie County. And when you apply the same laws, it doesn't fit well. But in any event, that's not getting us anywhere. Now, as far as if the court continues it, as far as making the schedule to accommodate this judge's schedule, that's not a problem. If you all could agree on a time, I could get the district court administrator to get somebody else other than myself. I don't want, it just couldn't be the local judges. It could be a senior judge from somewhere else. So if I did have an open date at the time y'all could agree, then I would stay on it. But if not, so my schedule does not, now the court administrator might not like me telling him that he's got to find somebody else, but he would be glad to do that. I don't I don't think it serves anybody's interest to put it off to the end of the session. I don't think, if anything that people of the state of Georgia and the United States of America now need is confidence in their elections. And that goes from the smallest cities, city council to the White House. I remember when we voted on paper ballots. I voted in the country in Turner County in 1966. And you had to unfold it. It was so big that you couldn't stay in the voter booth. So I got down on the floor in a little country voting booth, about 12 by 12. And I have to confess, the people running the polls, I said, I don't know him. Who's that? And they said, oh, he's a pretty good fellow. You ought to vote for him. In today's world, they throw it out. But I was a student at Georgia at the time. And back then, you didn't register where you went to college. You stayed registered at your home. I think that was a pretty good way to do it too. But anyway, I'm gonna give y'all a few minutes to see when y'all can agree, if you can, on when you do this. And the expert testified. I was trying to figure out what an expert would testify to about the accuracy of where they assign somebody. Yeah, I found that out when I was in Muskogee County last year. A guy came in and said they had a hangman's noose they found in the woods not far from an African-American person's house. And they were trying to find out who did it. And he wanted to build a geofence around it. I didn't know what in the world he was talking about. Anyway.
Get ready, because the judge is about to tell you how to successfully commit a crime without getting caught.
It's like 300-foot square fence around where that was. And they could tell every cell phone that walked through that square within the past 18 months, I think he said. Wow. If you want to commit a crime in today's world, drive a 1957 Plymouth and leave your cell phone at the house. Because I promise you they can find out where you were. If you do either one of those, take those with you. I don't think 1957 Plymouth had all that technology stuff. But I'm gonna give you all a break, and y'all let me know what you've done. My staff, also known as my wife, tells me that I have a doctor's appointment on the 27th, and she has a pedicure appointment on the 28th. But other than that, we are free to go. So I understand it was the 28th, right?
There we go, MYCO and Miguel. We don't have Judge Reeves right now. He hasn't been on since December. But we had a taste of him here. Oh, I love listening to that judge. Bonjour, Charlotte. Okay, back to this Opapari guy. He's on the stand. Kimberly Hurd is trying to question them, although it's not a straight line.
Excuse me?
Did you address this with me, this concern that you had?
Did I address what concern?
That I was overworking her? Or had her too
I-
involved?
Just like every other parent, I told you that she doesn't need to be in all these things.
How many do you feel she should be in? You said 4 days a week, that's what I had written.
How do I think she should be in? You can't put a number on that.
So then 4
She was
days-
in soccer, she didn't like it.
Okay. What activities did I have her in?
I just answered that question, I
No,
don't know.
specifically, you said 4 days a week, multiple, what? which
I don't
one?
remember everything you signed up for, that's what I said.
So you don't know whether she liked it or not, or that did she like it?
I don't know, she can't communicate like that. You ask her if she likes something, she's gonna say yes regardless.
So then what are you forming the basis of? Did you see her progress during this?
She's been progressing for a long time.
I mean, children progress, but,
If I can, Judge, and this isn't
Hold
an
on.
objection, I don't mean this, I'm not trying to step on you, I think sometimes there's a disconnect in that there's a question asked and Mario's answering a question, right? And there's a point that you're trying to make, and so there's a disconnect maybe between the question and where you're trying to go, and so it feels like you're going around in circles, right? And I'm not
I know,
faulting
I
you for it, and
can't-
I'm not faulting him, I just
can't
think
make
that's.
statements, I just have to
I know.
accept whatever he takes.
It's difficult, it is difficult, but I think
I
that
can't say
that's,
anything.
there's a little bit of that disconnect going on.
I do think he may be on a different narrative plane than you. You're trying to elicit certain information. I'm not sure he's
This is where.
picking up on it. Maybe if you could make it as clear as possible, it might help a little, I guess. I don't know.
So this is, okay, I'm trying to, when I ask questions, I'm trying to establish what I thought was, the way it was, and I'm learning that it's not. So I'm kind of, that's where I'm
Well,
having issues
if you can
because-
if you can avoid like combining 3 or 4 questions where you also add narrative or opinions of your own, like, well, as you know, I was out of town and that was the best I could do, and yet you didn't call me and then include 3 or 4 questions to him. So you just have to take it small blocks at a time. And right now you were you were asking, why am I precluded, in your opinion, from being a candidate for joint physical custody?
It's a YouTube video. I'm playing it right from YouTube, with the volume up the whole way.
He started discussing drug usage, and your thematic view on this case is that you no longer have any such issues, and I don't know if he said he is it, and you asked him if he feels otherwise. I think he said he did, and he said based on what he observed here today or whatever. So if you want to continue with that, or if you wanted to move on to the other.
Yep, I'm using streaming software, but all that does is stream. It won't boost my audio. It won't clear my video. It doesn't do nothing. Just doesn't work sometimes.
A couple issues, reasons why he offered this. I forgot what the other he offered another couple reasons of why he believes you shouldn't have custody. Referenced, I think, one of the old incidents. So his answer was, you pointed out past versus present, but I'm not using it anymore, and he says he's more or less, in so many words, he's not sure of that, and he thinks you might be. And I told him I didn't see any indicia of that, nor do we have any testing, so that's kind of where we are on that issue. But you did ask him about what other reasons, and he not only mentioned narcotics, but he mentioned you, histrionic behavior, or you showing up there and whatever, however it was. Past drug use, breaking into house, don't trust her. That was sort of what he said. Those 3, past drug use, broke into the house, apparently the 3-year-old incident, and just three in general, just doesn't trust you. I think that's pretty much where he's at. So certainly that lacks those are very general conclusions. So if you want to dig in for any specifics, I think that's what you're attempting to.
Yeah,
So go
that's-
ahead.
Okay, okay, so. Okay, the specific incidences then, can you do specifics, like?
Of which one? The drugs
Of-
showing up unannounced, or just not being trustworthy? I guess
So-
those could bleed over indeed. each other, but he
Okay.
mentioned those three. Are you still on the drugs thing, or, okay?
Well, I think we did that, right?
Yeah, unless
then-
he has some reason to believe that we haven't, you know.
Okay, so, we're just kind of going all over the place.
How many times today alone, on the 24th, did this judge practically beg these people to ask him to get her tested? And none of them have. But we all want that.
That's why it's important to try and get a little clarity and focus.
So the last. So your opinion, what is, of me, your opinion of me as a mother? What is it?
Controlling,
Okay,
don't want to co-parent?
is that the way it's always been,
Yes,
since she was born?
yes, and even before that with my kids.
Okay. What steps did you take?
Tried talking to you. Tried communication.
To. So you're pretty much saying I've been a bad mother since Adam was born.
I didn't say you've been a bad mother.
You have a lot of concerns since she was born. You've tried to talk to me. I don't respond. Is that what you're saying?
When we've had our conversations in the past, when we were together, you don't, always ended up in an argument. Because you even told me, it's your way is better than my way.
What ways was that?
There's no specific thing, there's no rule book on the parenting. But
So
you
if
said
I'm
it
telling
was
you
your
that my way
way.
is better than your way, what was my way? What was your way?
We co-parented different as long as we get to the same result. And that's raising good kids.
Is that not a good kid?
She is now. She's getting better.
So now you're inferring that she wasn't?
No, I'm not saying that. She's getting older. She's growing.
Okay, going back, specifically. What were the specifics?
Well, you kept comparing both my boys to your son Nelson,
Wait,
which
with Aslan.
you called, I'm not going to use the words you called my sons. And they don't deserve what they have or what they get because they're not Nelson. You raised Nelson the right way, not the way I'm raising my kids.
Wait, with Aslan.
Comparing. You're
I'm
asking me,
asking
you're asking me
specifically about
about you being a parent. Weren't you a step parent to my kids? That's what you're asking.
I'm asking about Aslan.
Okay?
So my way, you're saying I had her too involved.
Yeah, multiple times.
And you're saying she was too involved with what? We were at extracurriculars.
She didn't have a break.
You're saying she was too involved with extracurriculars.
During a stretch of time, yeah. Sometimes.
Okay, but you, specifically,
I'm gonna,
you can't remember, so this is where I'm trying to, like,
I'm gonna interpose an objection and it's vague, and I think if we talk about a specific time frame or something like that.
I think we need to link that more. I think she asked about the time they were together, but yeah, it might help to determine if he still thinks that that's an issue. He's had the custody for a while, so he hasn't needed clearance from her on activities. But she is asking for examples of where she asked him a few times, you're saying I loaded her up on too much instead of just letting her be a kid. What are examples of the activities that you objected to that I loaded her up on? And it's a legitimate question, so if he doesn't have specifics, then she can move on.
I just remember seeing the sheet, and having her signed up from 3:30 to 4 o'clock, or 4:30, and then 4:45 to 5:30 for activities. And one activity you had her enrolled in, she was supposed to be in school. A couple years ago.
What school?
It was either Lamping or CT.
You don't remember which one?
Is it, they went to school at the same times, does it matter which one?
It does, because,
I'm just asking, I don't remember exactly what school was, but one of her appointments was like 1 o'clock in the afternoon.
oh, what was that for?
I don't remember. I don't remember exactly what activity it was for, but it was through the city of Henderson, I know that.
Okay. Were you aware that she had received a grant?
Yeah?
Were you aware of the amount of that grant?
No,
I sent your attorney, did you get the paper?
I don't remember the grant.
Okay, it was for $200, which is free. It didn't cost any of us any money. Were you aware that there was a time frame to use that grant?
Not that I'm aware of.
I sent, and there was a time frame. Grants are conditional, you have time frames. You weren't aware that that had to be used within a certain amount, a period?
I didn't apply for the grant.
So you were unaware that I was applying for the grant?
Yeah, at the time, until I found out you had it.
Were you aware that I applied for it before too?
No.
When I was living with you, you weren't aware that I applied for the grant?
No, I don't recollect that.
With the grant, alright, so now, alright. So you think I have her to, okay, extracurriculars. What other activities did I have her to involve in?
I've answered that question already. I told you I don't know all of the exact ones that you had.
Okay, so I had her to involve, first you said extracurriculars, and she's way too involved, 4 days a week, overlapping with the school, but you don't remember which school. And you don't remember exactly what sports.
Not really.
Okay. Were you aware of her involvement with the Down syndrome organization?
She was for a little while. And then she wasn't for a while, because you stopped we stopped taking her there because you didn't like the way it was ran.
Alright, was she involved in other organizations?
We did a buddy walk in Arizona for that Down syndrome organization.
Right,
She wasn't involved in it, it was just a walk.
okay. What about advocacy work?
What about it?
The Golden Knights Princess,
That's something we called her.
okay.
She's not the official Golden Knights princess. She was never labeled that by the Golden Knights themselves.
Okay. When we, did she receive a car? Electric car that she could drive,
Yeah,
or it could be remote control. Do we have that car wrapped?
I did, yes.
Okay. And who'd you get it wrapped by?
Friend of mine,
Who was that?
Todd,
When we went to get it wrapped, we wanted to put Golden Knight, or what do we want to put on it?
we wanted it to look like the Lamborghini that the Golden Knights had the first year.
Okay. And did we ask for a specific logo on it?
Told them we wanted exactly like the Lamborghini, the Golden Knights logo, and say
And what
Vegas
about
born
her
on
name
sign.
or anything to do with her?
We put Golden Knights Princess on the back, it's a nickname.
Okay. Did Todd tell you that he had to get that approved?
He said he called them and got approval because he does a lot of paper printing for them and didn't want to step on any copyright infringements. So he got the approval that he could do it, and the Golden Knights gave their blessing to do it without having to pay any royalty fees.
You know, it's always difficult because the other side will say, oh, you're trying to help someone representing themselves, but I don't think anyone benefits, particularly the court, by getting into minutia of these couple 3-year-old disputes, and I understand, maybe even more than 2 or 3 years, and I understand that you're dealing with this in terms of the cooperation issue, or him saying you're uncooperative, but basically, you asked him 3 main things, you started pursuing one and you dropped it, he said drugs. Again, you have the opportunity to ask him what his concerns are, does he have those same concerns now versus then, and what's his proof of that? I think you tried to ask that, you can return to that. He doesn't trust you. Why don't you trust me, rather than this excruciating hyper-technical detail about individual disputes which don't seem that serious to the court? And him saying the
Excruciating.
3-year-old break-in
Yes.
incident is still a reason he believes you shouldn't have custody. I think he gave you 3 things which you could easily run with and challenge and see what he has on those issues. Instead, we're getting into this meandering, confusing thing like, well, on June 18th, 2020, you told me that, you didn't tell me about that appointment till 3/18, and you should have told me by 3. I mean, it's getting into this, it's getting into some really hyper-technical minutia. We're getting into the weeds on things that is not gonna score points for anybody. So, again, he provided information that you have great latitude with. Again, he says, he had drugs, he mentioned drugs. If you wanna develop drugs now versus drugs then, and what concerns or proof he has with narcotics
Okay.
now, you can pursue it. He doesn't trust you now versus then, still doesn't trust you. Why doesn't he still trust you? 3, why does the 3-year-old break-in matter? I mean, I hate to be in a position, but I think I kinda have to, unless we're gonna go around and around with this dialogue that neither of you seem to be enjoying, and you're both getting frustrated by, quite understandably,
I
and
think
which
I'm
doesn't,
misunderstanding. I
it
thought-
doesn't benefit the court. Sometimes the more details we get in, the better. And I understand it started off with a legitimate question, give me specifics about how I overload her with activities, but then we get into debate, well, who approved it and approved what activity, or what activities even existed, or what's, so, again, if this comment helps focus you, and candidly, I often do the same with people represented, I don't have to deal with that in this case, obviously, but sometimes a person represented, the attorney's not doing a sufficiently skillful job, and I have to intervene in the same fashion.
Okay.
So,
I just.
so
I think
does
it was
that
understood, like, I had to get more specific,
does that
but not
direction help you at all? Because candidly, when I help you, I'm helping them as well, because if these issues are of legitimacy, you get the focus on it, and if they're not of legitimacy, then they have much more clarity on how to rebuke those matters or convince the court that they're not in operation. But instead, if both sides just have the court confused by this type of dialogue that's not fruitful, I hope everyone takes my remarks in the spirit they're intended. Is that helpful at all? I hope it is, and if so, please proceed. Let's just drop this thing about this last appointment, God knows how long ago or whatever it was. Let's just proceed.
Okay. So you don't trust me,
Okay, you said it, let's get into that.
okay,
Go ahead, you don't trust her?
No, I do not.
Okay.
and this was due, you said to a break-in, that's one of the incidences, right?
That and drug use, yes.
Okay, so you don't trust me because of the break-in and drug use. When was the break-in?
March of 21.
Is that the one that we questioned your mom about earlier?
Yes.
Okay. And then,
That was the same day you also stole money out of my bank account.
so we're gonna add more to that. And have we broken up by then?
Yes.
And I reached out to you about trying to get, my property, or,
You had your property. You moved out February 8th and took all your property. You came and wanted to take Aslan stuff.
had I reached out to you about Onyx, or my dog?
Yeah.
Were you aware that I wanted him?
If I remember correctly, I told you to come get him.
But he was still at your house.
I'm sorry?
He was still at your house.
Right. I didn't tell you to come get him that night when I was out of town.
Did you let me take him that night?
I wasn't there.
But did I take him that night?
No.
When did I get him?
You never got him. You didn't want him at one point until he was about to until we had to put him down.
Isn't it true that we have texts, and they're submitted into evidence of me asking for him multiple times? Do I need,
I don't know, I would just, point of clarification, I don't know what text you're referring to, but there are no.
the talking parents?
I don't know.
And
where
I don't
that
know,
comes from.
it's a little tricky because
And this is 3.
if we're dealing with, should she have, did she, if you wanna call it breaking, did she break into the place? That's how it's classified 3 years ago. Number one, is it even relevant? And number two, if it was wrongful for her to do that, is it justified by whether or not she had all her stuff transferred to her yet? So we may be going down some place which is tangential, where we're implying that if something wrong did happen, that it's okay based on whether her stuff had been returned to her or not. It was either a really disruptive, wrongful, impulsive, shocking act, or it wasn't. And if it was, is it still relevant 3 years later? And if, whether it was or not, is not really, if it wasn't justified, it's not justified by getting into the weeds as to whether she took all her stuff on February 8th or not. So it's, these things aren't like logically connecting necessarily the way they should, but let's proceed. He doesn't like he views the 3-year-old incident a lot differently than you do. So, and likewise, so vice versa, so. Now, I'll ask a question, since he thought that was extremely, not just unreasonable, but outrageous what you did. Well, you think it's reasonable. Did you send him any email or text saying, hey, when I left on the 8th, I didn't get puppy and I didn't get to take these other matters?
Yeah,
you-
we had
Okay.
conversed about
And
it.
you're saying that's what's in evidence that you
Yes,
asked? Okay.
but I can't say anything right until I'm,
Okay,
right, that's what I'm instructed, I can't.
I just asked you.
Okay.
If you're saying it's in the exhibits, okay, we'll look for it later, okay?
Okay. I didn't know how far I have to go.
Point of
Yeah.
clarification, I don't know if Ms. Hurd's aware, just because you're being so helpful.
And I think it's causing more confusion, though.
Well,
It's having the opposite effect, though.
I just think that, if I can say this, prohibited liberty, and if I'm too far, Judge, please tell me. I think there may be a confusion that if there's a piece of evidence that Ms. Hurd wants to work with, she sees.
Sissy, thank you so much. Thank you.
Her statements to the court, I think that perhaps some clarification on if she has some evidence that she'd like to show my client, that now would be the time to do that.
Yeah, I was thinking the same. You don't necessarily have to wait till your case. If you have something that you're ready, that you want to show him or even ask for admission, you can do that while he's testifying, if you have anything like that. But if you're saying, I do, but I have to go back and dig for it, then it might be best, as you suggest, to return to it later and just proceed forward. So it depends how available it is, really.
Okay.
If you don't have it at your fingertips, maybe, if you do, great, you don't have to wait till your case. But if it's not quite available, then you can just proceed with the question and return to it later.
Okay. Was there any other issues as far as breaking in?
Putting tracking devices on my vehicles and a voice recorder in Aslan's diaper bag.
Was there any other break-ins?
Not after that time, no.
Right, so establish that, okay. The drug usage. We were talking about 2014, you said, one time, is what you found?
I don't, roughly, a few times, a couple times.
And one time in 2015, you said you found?
Yes.
Okay. prior to that?
Prior to what?
Those two incidences?
The time you were hooked on pill, I mean, what? I don't understand the question.
You said that extensive drug use. And you're talking about one-time incident in 2014, one time in 2015. I'm just trying to establish this extensive
I
drug
would just
use.
interpose an objection to be helpful. I think it misstates his testimony insofar as he was responding to, had he personally found narcotics, and those were his answers.
Right, I mean, we're aware that there were drug testing in this case much more recently, et cetera, and other incidents. But yeah, the questions were limited to paraphernalia that you located in the home. And I think that's what you're asking. You said once in 14 and once in 15. But yes, he's not necessarily saying that he has no concern about drug usage subsequent to that. But in fact, he made quite an issue of it in this case.
Okay.
But yes, he only found it once each of those 2 years.
So now you're saying you were concerned about my drug usage. You weren't, but now you are.
Yes,
In the last, how long have you been concerned about that?
I've always been concerned about it.
So you've always been concerned. How many times did you ask to have me drug tested last year?
Last year? None,
How many times this year?
none.
In 2022, how many times did you ask me to get drug tested?
However many times I had my attorney inform me to go get drug
You
tested.
mean 21, because he just
Wait.
testified in 23 and 22 none, because he already had the sole custody order and this was on appeal, so there was no ability to request anything. So I think you mean the previous year, right, 21? Or maybe I'm wrong.
22 and 21.
Yeah,
22 and 21. 22 was trial, started in 20.
right, so,
Okay,
okay, so he said none in 23. Okay, let's go back to 22, whether there were any
okay,
requests.
22.
No, in 22? Okay.
Yes,
Yes.
Then I guess
Yeah.
21, no. Okay, okay.
So you could do random drug tests, correct?
yes,
And how many times were you allowed to do random drug tests?
And you mean total or in the year of
Once a month.
2022, the whole year?
Yeah.
Okay.
Once a month, okay. Did you drug test me in March,
Of what year?
2022?
I believe so.
Okay. And did you in April?
Yes,
And did you in May?
I don't remember, and I know there was a month or two I skipped.
Okay, in April, we had a hearing, correct?
I don't know exact dates, but
Okay, so we had and what was the, award, what was the, order from April
Of
2022?
what do you mean the order? The court
For,
order?
random drug testing,
I believe it was once a month.
okay.
And I couldn't, if I tested you twice in a row and you were clean both times, I couldn't test you a
Sorry,
third time,
Charlotte, I
believe is what
tried.
Your Honor said.
Before the hearing, before the evidentiary hearing.
I pretty much
Fletcher,
had
thank
tested
you.
3 times before the trial.
Yep. Yep,
Did
yep.
you test me in June?
No,
Did you test me in July?
I don't believe so, no.
And then in August, did you test me?
Yes, you didn't show up for it.
Okay, Mr. Friedman, so I don't, in interest of both parties, so I don't have to hunt
It's
for
all
this
in evidence.
information, what months did we have, what months were the couple positive drug
The
tests?
original drug test was November of 2011, Judge.
Right, okay.
Or 2021.
Thank you, Fozzie.
Yes, and that is, and that led to a series of orders, for custody, resulting in those pickup orders, and then we begin the periodic testing, Judge, and I'm just pulling them up, they're already in evidence for the
Yeah.
court.
They might even be filed here, I'm gonna look.
They are, Judge, so the,
Pay attention, see if you agree with this, the chronology.
so the original test is, at Exhibit 13 is November, which,
Okay,
which is at Exhibit
November
13,
2021.
November of 2021. Then we have a test in March of 2022. That is at Exhibit
Sorry,
15
Charlotte.
in evidence, positive for alcohol. First one was Matthew Armswear. Then we have a test in April of 2022, April 15th, 2022. That is at Exhibit 17. That is positive for alcohol. Then we have a test, it looks like on the, this is at exhibit 19, this is May of 2022. It shows a positive for a substance I'm not aware of, but it does appear that, well, actually, this doesn't note it, butabidol, but I know that defendant has indicated there may have been a prescription
She
she didn't furnish or
declared a
something.
prescription for
And so that was the May test, and then Judge, there is the requested test, 12 days prior to trial in August of 2022, which is a presumed positive for substance because Ms. Hurd did not appear for the test, and that finding is contained in the court's decree of custody or order following the evidentiary hearing. And that is, the letter requesting that formally is at exhibit 20 in evidence.
Okay.
And then the court communication at exhibit 21 from American Toxicology Drug regarding defendant's failure to appear for a drug test on August 4th. Again, email correspondence between court staff and the ATI, and as I said, that is exhibit 21.
Okay.
Thank you,
20 is the request,
JK.
21
Thank you
is the
so
correspondence
much.
between court and ATI regarding this test.
Okay, so by way of review, 13, which was November 2021, urine barbiturates positive, 85 nanograms, meth, 83,587 nanograms, and amphetamine 19,564, and then in hair, amphetamine positive 640, meth positive 3675. That was back number 13 in November 22. And then just take notes on this in case you want to follow any of this up. The next one is the exhibit 15. Test was March 2022.
That's correct.
Alcohol positive, not as much going on. Hair, everything's negative. Urine, alcohol positive at 0.1. And then apparently positive for a prescribed medication. Then number 7, exhibit 17 was a month later. April, kind of the same, he's got negative in the hair for alcohol, alcohol positive in the urine, but dropping to 0.084 from the 0.1 of the earlier test. And then apparently the prescribed medication that was just referenced. And then that was April. Okay, and then May, which would be 19, May 2022, exhibit 19, positive in the urine for the prescribed medication and negative in the hair for everything, so that's good. That one's good progress, but then the requested test of moving to August 2022, right before trial. It's a it's a request from the attorney dated August 4th, 2022, and it indicates there's underneath, there's the proof of receipt. As you are aware,
And then at 21,
yeah,
judges, the
and then
court's
at
confirming
21, the court's,
correspondence with ATI.
correspondence with ATI from the court confirming you didn't appear. Let's just get that out of the way and then you can proceed with the questions. Do you wanna wait till your testimony is, did you know or not know about, did you receive the August 2022 notification?
I did receive it, but I didn't receive it when they sent it, it was
Okay.
delayed.
Okay, then we'll pick up on it in your testimony, okay. But
Later.
that's, as Mr. Friedman laid out, that's the documented history of hopefully that's useful in your question, and that's and there did seem to be some real progress on your part, so I think it's editorial remark, it's a shame that we didn't have the test in August 2022. Okay, but you can proceed.
Judge, for the record, just so we can clarify, attached to the letter that Shaka sent at exhibit 20 that you were just referring to.
Correct.
There was a representation by Ms. Hurd about receiving it, but attached to that same exhibit is the log showing the date and time it was opened
Right.
by Ms. Hurd.
At 2:47, is that correct? 2:47 PM.
Okay.
Yep, that's what it
So
says.
I had till the next day.
Okay, let's proceed with the question of him then, based on, you were discussing his concerns about drug usage. Then there's the testing history, so you can proceed with your questions.
All right.
All of them, JoJo. All
Were
of
you aware
them.
that I had offered your attorney to do random drug testing immediately after that November incident?
I don't remember.
She didn't notify you of that?
Terry, thank you so much.
And this was November 2021. She never made you,
I remember you had the drug test that day.
right, and then I had were you aware that I had a settlement conference with your attorney the next day?
Mm-hmm.
Okay. Did she discuss with you that I told her I was willing to do random drug testing?
I'm sure Ms. Hurd doesn't mean to just objection, it seeks to invade privilege. I know you don't mean to, but you can't ask him what he talked to his attorney about.
You can ask him if you can ask him if you're aware of her offer, but anything in
Okay.
further detail than that probably does invade. You can,
I'm not looking to be difficult, Judge,
Right, I know.
yeah.
I'm not sure he's able to answer it anyways from from how it sounds, but go ahead.
Alright, sorry.
Okay,
Okay.
please.
Mara, I want to give you an opportunity to clarify and provide the court some more detail about some of the topics you just discussed, okay? So, one of the incidents, one of the factors about your concerns about Ms. Hurd's parenting you talked about was trust. So I want to just make sure I can clarify.
Probably from drugs.
That with you. You mentioned the break-in incident, and that was, you recall that?
Yes.
Okay, and that was in March of 2021, correct?
Yes.
Okay. And you sort of started to expound upon that wasn't sort of an isolated incident, that it actually encompassed a broader spectrum of behaviors that occurred that day that born on trust. Is that correct?
Yes.
Okay, you said something about money being stolen. So what were you referring to?
I got an email notification that my bank accountant sent $750 payments to 2 of her credit cards, and she's owed herself $3,000,
Okay.
and then manually withdrew $500 out of an ATM.
Okay. And those transactions were not, the significant sums of money therein were not disbursements that you had approved to happen, correct?
Yes.
It wasn't your intention to gift her that money.
No.
And in fact, you reported that to law enforcement, did you not?
Yes.
Okay. I'd like to take you, if I could, to our exhibit.
JK, thank you so much.
That's our binder, number 1, it'll be at exhibit 9. And I would remind everybody, this is already in the evidentiary record. Exhibit 9 and binder 1, that's right.
Monica, thank you so much.
Whenever you're, I'm not
Sorry.
trying to rush you, go on.
The other one.
I don't want to start when you don't have it in front of you to be fair, so. right, so that's at our exhibit number 9, Mario, and this appears to be a register of actions for a criminal case. Do you see that?
Yes,
And this is the state of Nevada versus Kimberly Hurd, correct?
yes.
Is this the criminal case that you're referring to for the monies?
Can you hold on one second?
Pardon?
I have it. These are not.
It's at your number 9 in the plaintiff's book.
It's our what you want for, and then
Last time Charlotte got a membership, it was because Lena's gifted one membership, and boom, got her. After we all have been trying and trying and trying.
Two of them are marked up, so. Alright,
By the way, was this, I know they weren't married, right? They were never married.
they were
Is
in there.
this account, was she listed on
No, Judge.
the account, was she a permissive user
No,
who you
Judge.
gave a card to or some access? Did she
She
take?
had, well, if you're asking me, I was gonna go through it with
Yeah.
Mr. Party, but just quickly, my understanding is that she had possession, physical possession of his ATM card, not with his permission, but that she had
Okay.
it. And
Because they
had
never
the-
would have prosecuted her, even
Right.
if she's not on the account, if he said,
Right.
if he made her permissive user, even informally,
I-
like I'm not adding your name on, but you can, here's my pen and you can take the card and Dire Straits.
Awesome try.
Yeah.
Thank you, Fozzie.
But obviously it did. So, Mr. Opari, obviously, Opari, I was informed, Harry, I'm sorry, I've been mispronouncing it this whole time, Harry. As you see, this is the 21 CRH 001184, State of Nevada versus Kimberly Hurd, right? You see that at the top there?
Yes.
To your understanding, I know this is already in evidence, but this is the register of actions for the criminal incident wherein she took those monies from your account, correct?
Yes.
And you see that just in that small paragraph below that heading, under action, it says action colon. It's in kind of small print, if I can approach the witness stretch for one moment.
And this was
No, I see it.
750
I
bucks?
see it.
Yeah,
750.
1,200, well, no,
Oh, 12.
the amount was in excess of over $5,000, I think.
Oh, so it was in there was evidence earlier,
Between
200 here,
1,200, but less than
200,
5K.
intervals of 200, then 750, so the total amount he asserted was removed was,
Well, the charge is between 1,200 and less than 5,000.
Okay.
I think he testified to 750 twice.
right,
And then $3,000, correct?
And then an additional 300.
And then 300 out of the ATM. So, obviously, Mr. Opari, it looks like this case was filed.
Kelly needs a membership too.
October 12th of 2021, correct?
Yes.
But your testimony here today that this relates to that March date, March 19th, 2021, when she was at your residence, correct?
so
Yes.
3,800 bucks, okay.
Okay, and,
About
sorry, Judge.
3,800 bucks roughly, 750 twice, $3,000 and then another 300.
That's my understanding.
Over how long?
It was all the same day, Judge.
Oh, because I was gonna ask, how did he not know if this
Well, it
was?
was all, his testimony, I think, Mario, correct me if I'm wrong, you were receiving while out of town, the same day that the police were at the house, you started getting alerts.
How did she get his,
The bank email.
how did she get his PIN number?
Well, she, my understanding, and this is
Without
what
him
I've been
giving it,
walking
without
through.
him providing it, either provides it to her or you carelessly leaves it listed somewhere, how did she get it?
Well, I think there's two things happened, Judge. I think the first piece is that she was able to go on using her own personal devices, probably from sometime when they were together, had a password saved in a computer or something, and was able to go on and make these transfers. None of the
Oh, okay.
accounts.
So it
none of
wasn't
the
a
accounts-
simple, it wasn't a simple ATM card type situation?
Separate issues, right?
Okay.
So none of the accounts were in her name, none of them was she an authorized user on, obviously, as you know, the court wouldn't charge on this. But, talking about trust, Judge, because you asked the question.
Sure,
so
sure.
we're trying to- So then, Mr. Opari, obviously, your understanding was this case was prosecuted by the district attorney's office for some time, is that correct?
Yes.
And during that period of time, were you in contact with the district attorney as they were prosecuting the matter?
A few times, yes.
Okay, and is it your understanding that the matter was ultimately resolved via a plea deal that she took,
Yes.
and that she did plead guilty to a criminal offense?
Yes.
Okay. And obviously, the register of actions of all this is in evidence, as I said, is Exhibit 9. So continuing to bear on trust. You mentioned the theft on that day that subsequently is prosecuted. You mentioned, right?
Yes.
You mentioned the break-in on the same day, where she went through the doggy door, a trust issue. And then you mentioned something else, which was sort of two things, but you said it in one. You said that she had put tracking devices on your vehicles, is that correct?
Yes.
Okay. And then you also indicated that she had installed some type of a recording device in your daughter's diaper bag.
Yes.
Okay. Mr. Akbari, it's the case that the listening device in the diaper bag was also the subject of a criminal investigation, and ultimately the charges were filed for that. Is that correct?
Yes.
Okay. So if I can now, I'd like to take you to, it's our binder 4. Again, I believe this also, this is not yet in evidence. So I'll be laying some foundation to introduce this, Judge.
I'd like to object.
It's marked, well, I'm gonna lay some
What was the
foundation.
ultimate, was it a gross, what did she ultimately plead to? Start out as a felon?
Which one are we talking about?
The
What am I-
2021 that we just, it was originally, the original charge, and what did she finally,
At Exhibit 9, the final disposition.
where is that?
I'm looking, Judge, for should felony arraignment.
Yeah, start out as a felony, obviously,
Yeah,
it
there
didn't
is,
wind
yeah,
up there.
it was not a felony ultimately, I know the
Yeah.
plea deal was for a lesser charge.
Okay.
I'm looking.
Why have it?
Okay.
While I'm looking for the specifics,
Okay.
charge of that, if I can,
I have
Sure.
it.
permit me to move on to
Sure.
this would be our proposed Exhibit 49.
Okay.
This is not yet in evidence. What this is, and that's in our binder 4, Mario, and Exhibit 49.
This one? Yeah. Let's have a look.
Your Honor, what I have for the court is an original in the binder you have a copy. What I have here in my hands is an actual certified copy from the Henderson Justice Court, certified as of 12/27/23, certifying that this is the certified copy of the Henderson Justice Court criminal
If
document.
it's certified, the court lacks discretion, it'll be admitted as long as it has relevance. And of course, any criminal charges against either of them have arguable relevance,
Your Honor,
so
would you like
it's
to-
it's admitted.
Well, my
Hey,
objection
You
is
can
that
show it to, you can show it to her.
I've seen it, but
When these are admitted, it doesn't mean that it doesn't necessarily mean that Wade is gonna put in, that the court's gonna make findings that they're relevant to the issue, I may or may not. It's just that they've satisfied the minimum standard of
I understand
admissibility.
that.
It doesn't mean the court's persuaded as to what the impact is. It may not have impact, I don't know, we'll have to see. Likewise, your exhibits that you, do you have
am I allowed to
exhibit?
object? 'Cause
If
I
you
was-
have, well, you can, but a
So I'm
certified,
gonna object, because my understanding is with the no low contest, however you say it,
Okay.
no plea or no contest, that's not admissible into a
well,
court.
it speaks to that, that's not, means it's not admissible as establishing a guilty plea or being found guilty, but a verdict of rendered guilty by not contesting it, essentially nullo. And if it's a certified copy, it is admissible, but you're certainly free to argue the court shouldn't consider it, or the fact you didn't plead guilty has some relevance, that's fine. Likewise, if you have exhibits that you haven't had admitted yet, I'm pretty liberal about admitting exhibits we're going to be having discussions about and showing to people, because speaking of remands, you get remanded 100 times more for what you didn't let into evidence, what you guys had a 20-minute debate and didn't admit it, because I think they want you to err on the side of admissibility, because admissibility just means there's some minimum establishment that this is genuine and that it's arguably relevant, and it's up to the court what weight. Most exhibits, the court doesn't wind up putting any ultimate weight on in the findings. So it'll be admitted. Likewise, your exhibits that you question him about, or that you present, presuming that they're adequate, will be admitted.
So, I was just gonna
Go ahead.
To adopt the judges, of course, we also know that when we do a no low plea, we have to stipulate to a factual basis. before
That
the
the,
court will
that
accept.
that the prosecutor has the sufficient evidence to prove their case, but I'm not
I
necessarily
understand.
admitting guilt.
Of course. So I turn the court's attention to what is now not a proper but an admitted Exhibit 49, which is a copy of the certified docket for the instance we discussed with the recording device. And Mario, are you looking at that exhibit there?
Yes.
Okay. And you see that the ultimate charge that results there at the top is harassment, correct? It's about 3 lines down.
Yes.
Okay. Now you do see that below that, it says guilty plea was sent before prelim. It says amended from, right? You see that? It says monitor or attempt to monitor private conversation. You see that?
Yes.
And you're aware that was a felony charge, correct?
Yes.
Okay, so take us through that. And ultimately, we know that this resulted in criminal convictions for harassment, not for monitoring or attempted to monitor a private conversation. But you explained that there was some type of recording device found in Aslan's diaper bag.
Yes.
Can you walk us through that, please?
I ran an errand to go get my haircut that day. Carrie called me and told me that she found a recording device in Aslan's diaper bag. So obviously I was on my way home anyways. There was a handmade sewn-in pocket in the diaper bag where the recording device was, and a friend of ours was over at the house, and we decided that I needed to check the vehicles, and I crawled underneath both our vehicles and found two
JK,
recording
thank
devices,
you so much.
or trackers.
Okay. And so then that was the same day that you basically discovered both a surreptitious recording device lodged into your home without your consent in the diaper bag, right?
Yes.
And then, upon being alerted to the existence of this recording device, obviously inspect the vehicle.
Yay,
and
Charlotte,
find that.
yay!
And how did you become aware of the fact that both the tracking devices and the recording
Jojo,
device
thank you
were
so
results of
much.
the defendant's actions?
Well, the diaper bag came from Aslan, or from her house, and just periodically there'd be times that in conversation through talking to parents or whatever we were using at the time, Kimberly would mention something that just seemed a little too obvious she knew where we were at.
And this was between July 1st of 2021 and approximately September 18th of 2021, is that correct?
Yes.
Okay. Would this be another sort of series of incidents when the court was canvassing you and Ms. Hurd was canvassing you about trust?
Yes.
This took 2 years to weave through the system, the harassment claim.
It did, Judge.
And the date of the incident was,
It was a period
oh,
of
here
time
it is,
between July.
it's in the, yeah, you just mentioned it, 7/1/21 through 9/18/21, okay.
That's right.
Because I got thrown off because I'm seeing all these 2023 dates,
Sure.
which would have been subsequent to our hearing.
Right. Well, I think at the time of your hearing, the reason that Exhibit 49 didn't exist at the time is at the time of your hearing, it had only just been filed at that point, Judge, as a criminal complaint. Again, just dot the I on that, you know, that incident, obviously, it took 2 years of your life, right? It was 2 years of your life you went through, and obviously the incident was late 2021. But resolution of that incident did not occur until 2023, is that correct?
Yes.
Okay, and obviously, we've already discussed that resolution resulted in the defendant taking a plea deal and a criminal charge being assessed to her as a result. I wanted to take you back, if I could, Mario, to something the court asked, because I wanted to answer its question. Judge, you were concerned about the March of 2021 theft and the ultimate disposition of that. It's my understanding, Mr. Opapari, please, correct me if I'm wrong, my understanding is that as part of a criminal negotiation, Ms. Hurd was ordered to pay you restitution, and in exchange for paying that restitution, the case was dismissed, is that correct?
Yes.
Okay. So that goes through that, talking a little bit more about trust.
I'm sorry, so, she wasn't ordered to pay restitution.
She was.
The 2021 incident where she said she wasn't even trespassed, that one,
Well, so it was the same day, Judge, and that's what's confusing. The day that she was at the house and the police were called because Mom was there and he was out of town, while he's out of town that day, he's getting alerts to, his phone from the bank, seeing these transactions, ultimately files a criminal report about that, and the result of that is a criminal case filed in October of 2021. Okay. Separate and apart from that is the recording devices and the tracking devices, which we just talked about at Exhibit 49.
Okay.
So those are big pillar issues, obviously trust, Mr. Papyri, but Mario, what about some other things that have eroded your trust?
Where's the best place in Australia to buy Fosters?
Has it been your experience during the course of this litigation in pleadings in an open court that the
Hi,
defendant
Crystal.
regularly refers to you as being abusive?
Yes.
Does she regularly claim that you're abusing Aslan?
Yes.
Claims that you medically neglect Aslan?
Yes.
Claim that you, did she make a point to regularly try to, in your opinion, record your phone calls with Aslan?
Yes.
Are these things that eroded your trust in her as a co-parent?
Yes.
Hi, Karen.
Let's talk about the drug portion, right? So trust, we talked about some length. Let's talk about the drug portion. There was some questioning by Ms. Hurd, and you pointed to a couple incidents, I believe 2014 and 2015.
Back off.
Yes.
And in those
Back
incidents, you described
off.
in a couple different ways.
I
where you
called
actually
dibs on that
physically
dog.
located and found what you believe to be illegal drugs in your home. Is that correct?
Yes.
And I believe your testimony was that, in fact, there was a conversation that ensued, and it was admitted by the defendant that, in fact, they were illegal drugs, correct?
Yes.
And it was, I think you said amphetamines, methamphetamines? Okay. But Mr. O'Party, and the judge, to some painstaking detail, went through the record of drug testing, so I won't belabor the point, but it's not your contention that those drugs issue, that drug issue was sort of isolated to 2014 or 2015, correct?
Yes.
Your concern, as I understand it, is that it has been a recurring theme from what you understand in Ms. Hurd's life for some time now. Is that correct?
Yes.
Now, I want to be clear about something, because I think this is very important. You're not sitting here today saying that it's your belief that Ms. Hurd, day in and day out for 10 or 15 years, has consistently abused illegal drugs, correct?
Correct.
What you're telling the court is that there's periods of time where her drug use picks up, and you observe certain behaviors, certain tells, or what have you. Is that correct? That gives you reason to believe that drugs are again a problem in her life.
Let's be aware that even though I think she called him, so technically it's a cross of her witness, but yet it's your party, your friendly witness. So you're kind of suggesting conclusions for him, and I understand it kind of speeds things up. But he has to say, yes, my concerns are, it
Okay.
can't really be spoon-fed to him. And I understand the answers are gonna turn out to be the same regardless,
fair,
and you're
Judge.
trying to save us time, I
That's
get
all.
it, but
It's fair.
it's a party, your party witness, so you
Yeah.
really can't lead to that extent, you know?
It's fair enough. If
Okay.
that's your instruction, I'm happy to abide by it, not a problem.
Okay, because I've been pointing that out to her repeatedly, so we have to have consistency with it. you know?
Absolutely, Judge, and you
Okay.
should. That's absolutely fair. So, Mr. Okapari, let me give you an opportunity. Can you describe for the court the type of concern you have over Ms. Hurd's drug use?
Very, okay, now that's very well phrased, okay, go ahead.
Can you repeat that? I'm sorry.
Can you describe for the court the type of concern you have over her drug use?
If any, yeah.
If any.
Well, I have concerns with her behavior, and, and being, when she has in the care of Aslan, being on drugs and, not being fully aware and fully responsible.
Okay, so over the course of your relationship, and you've known her a very long time, I don't mean to imply romantic relationship, I mean to imply that plus the entire time you've known her, okay? Over that course of time, have there been periods of time when you have concluded that she is, or observed that it appears she's not using drugs and she seems clear-headed and sober?
Yes.
Okay. Conversely, have there been periods of times where you've noticed sort of resurgence of what appear to be symptoms of drug use?
Yes.
Okay. Is it fair to say that that has been what has guided you throughout this litigation in requesting drug tests or not requesting drug tests?
Yes.
Okay. And so the court has some sense, what are the types of things you've come to associate with Ms. Hurd's active use? What are the types of behaviors?
Extreme weight loss in a short amount of time, erratic behavior. As long as I've known her we have known each other since high school, but since I've known her till now, she's always had blonde hair, and then just for a 6-month period had brown,
Okay.
right after she failed the first drug test.
Isn't she still blonde now?
I haven't had money to even do this is my real hair color.
What about, you explained that, talk to me about, are there any things you noticed in her demeanor, her body language, her hand gestures, facial gestures, etc.?
Jaw clenching, twitching,
And
not being able to focus.
have those types of behaviors and you noticing them, have they seemed to accompany discord or an inability to cooperatively co-parent or deal with issues with Aslan? Is there a correlation there, or
Yes.
are they separate and apart?
I think there's a correlation there.
Well, I suppose, you don't mean to say that when you notice those behaviors, the co-parenting gets better, I assume?
Correct.
Okay, and what do you notice, if anything, about, again, you're not a scientist, you're not a doctor, you can't conclusively say this, but when you assume, or when you seem to believe that there's active use going on, what are the types of co-parenting problems you've run into with Ms. Hurd?
Communication and really just being able to agree on things and, being constantly told that I'm abusive and hostile.
Okay.
And all the accusations that are thrown out like that.
Okay. Now, you recall that we discussed, and again, in evidence, I don't need you to turn to it, but in evidence at our number 20, exhibit 20, and at 21, was the August of 2022 drug test request, and then correspondence about it not being taken. Do you recall that?
Yes.
Okay. Now, obviously, my recollection, and correct me if I'm wrong, was that that was very close to the date of trial, correct?
Yes.
If I recall, was it about 12 days?
Yes.
Okay, so 12 days prior. And were you experiencing or having a sense at that time that drug use might be an issue, and is that the reason that you requested the test?
Yes.
Okay. To be clear, Mr. Party, at this period of time, you had had, as a result of the drug issue and a myriad of others, you'd had sole custody of Aslan for nearly a year at that point, correct? About 10 months?
About 8 months.
But could you have him complete the arc of the questions about, you said, yes, I did have the concerns 12 days.
Sure.
I had renewed concerns 12 days before trial. Let's find out what prompted that.
Mr. Party, what, give the court some specifics about what, in the run-up to that trial in August, what was it that made you suspect that drug use was an issue?
Just some things that happened between communication. We were traveling out of town that weekend. She requested itinerary. I sent her a screenshot of the plane tickets, and she said that wasn't good enough, and then started blowing up my attorney at that time. And then just a communication issue.
So is that sort of the linchpin being the nature of the communication, in your experience, being not an expert, seemed to change when you suspected drug use was an issue?
Correct.
And if I recall correctly, you had not requested a test in June or July.
Correct.
Okay. And so I presume it to mean that, is it fair to say that maybe perhaps during that period of time, you didn't suspect that drug use was an issue at that point?
That, and I was also trying to save some money.
And at that point, if I understand correctly, Aslan was in your sole care, correct?
Yes.
So there wasn't this exigent health or safety issue relative to, if she was using, Aslan wasn't in her care at the time.
Correct.
In fact, I believe at that point, the exclusive forum for visitation was at family's first supervised visitation, correct?
Yes.
So that's drugs. And I want to touch on one piece, because I know the judge had some questions about it, and I want to give you an opportunity. When the judge asked you and you said, and maybe you misheard, your concerns about drug use and were you concerned today? And I think you said sort of something like, oh yeah, I'm concerned today. Obviously, you're not speaking on the telephone to Ms. Hurd on a regular basis, correct?
Correct.
So, with the complete understanding that you are not a certified drug expert, correct?
Correct.
You are not a doctor, you're not a nurse, you're not an Indian chief, so to speak, right? You have none of those certifications. What led you to have a different opinion today about the potential that maybe Ms. Hurd might be, you know, struggling with youth, as opposed to the way you felt about that when the judge queried us on this, say, 2 weeks ago?
Her demeanor and her body language,
Okay, can you be a little more specific for the
the
board?
clenching of the jaw, the twitchiness, not being able to focus, the rapid eye movement.
Okay,
And-
let's hold on a second. Here's the problem, I think, I'm being asked to, and sometimes that's appropriate in a case, to observe court demeanor and juxtapose it with earlier court demeanor. I'm at a disadvantage here. I haven't really noticed anything. I mean, sometimes I'm busy taking notes, looking at exhibits, something on the screen, reacting to questions, absorbing material, so I don't
Candy
tend to
Crush.
look much out at the parties, and when I do, I need the eyeglasses for assistance. So I haven't necessarily, are you saying that, and I know you're not a recipient witness, you're the attorney, but but it's appropriate for an attorney to comment on this, not as a recipient witness, if it's so glaring or outrageous, but have you observed this, or?
So if
I haven't really-
If I may be as candid as I
Yes.
possibly can, Judge. This morning, for about an hour, yes, I absolutely did. Now, that does not mean, Judge, that I know for certain that that's the case, nor does it my client, and I think my client's trying to offer you the same perspective, which is, we're not experts. All he knows is what he sees. We willingly admit there are nerves involved. There is a lot of stuff, but just having seen Ms. Hurd conduct herself, where previously nerves were involved, and, in fact, demanding your honor recuse yourself, and the way that the composure there versus the way we started today gave me some pause. I also know for the
Well,
record,
but that's
Judge,
where I think
know-
she's more composed
well,
and
that
civil.
wasn't-
I think our exchanges between her and
You and her,
have
sure.
been more civil.
You
than
and her, sure, but not, you asked me my opinion. So, I also note that when we discussed it that first day, Ms. Hurd was very adamant that she would run out and take a drug test.
Okay.
And today, when it was broached, did not hear a similar, proclamation. I also note,
But
that
I
she-
asked you, do you want me to
she-
extend that to her? Are you interested? Because
What?
from your side, I really can't make conclusions
Oh, I know.
based on
I know.
opinions, my own observations in
note that
court,
my
which I didn't really observe anything, but even if I had,
Just say
for
yes.
something this critical and serious, I'd have to have a toxicology on it. And
Sure.
if somehow, because this case is so involved, unfortunately, it's not gonna be a decision today. We have to come back for another date. So if anyone, I'm not saying you will be sent or he's gonna request it, but if he is gonna request that, is that something you might agree to and get out of the way, or you wanna think about it, or you don't know?
I've asked him for the last 6 months in text, and he says no, no.
Okay, so if he's willing to
Yes.
pay for it at the conclusion of these proceedings, and you haven't, a prescription or otherwise, is it just pure nerve, if what they're saying is true and it's, let's assume it's nerves, have you changed anything about your prescription routine or any dosage or interval amount
No.
with anything, or is everything the same as it was?
No, it's less,
Okay,
so,
and let's say a 6-month period, for the last 6 months, have you ingested any non-prescribed narcotics of any sort?
no, I haven't.
Okay. All right, and that's under oath. You're free to request. It sounds like if, at the end of these proceedings, if you think it's relevant and you want the court to make a finding, she's willing to go if you guys prepay it.
Okay.
So
And I
we'll-
would just note that the other piece, Judge, was the not coming to the doctor's appointment and then also foregoing a visitation, which also occurred since the last time we were here. So it's that combination that, again, I'm not saying, and I don't think my client is saying, we know. We don't wanna make careless accusations, but we still have a young child to contend with, and we have a littered record with this type of thing. And so he was asked the question, I think he answered it honestly.
Okay, we can come back to it. As long as everyone knows, I don't really care to revisit the issue, but parties have the right to, as long as it's understood with clarity, and I repeated 16 times, I will make no current narcotics abuse findings if we forego a test at this time. And she's willing, do I understand? If they request it, you're willing.
Are you willing?
Pardon?
Are you willing, Mr.
Yeah, I have a question.
Okay.
This is where I'm like damned if I do and I'm damned if I don't.
Well, sometimes
So-
that is the issue with drug requests, yeah, so.
And am I allowed to talk to what they're saying, or,
Well, more to the issue, well, yeah, we want to get back to the testimony, but if you need time to consider the question, whether if they request this if you're not prepared to answer it now and want to wait until someone actually requests it, which they very well may not, you can answer at that time if you need time to think about it. If you don't think the intrusion's appropriate at this time, because you've jumped through enough hoops, that's fine.
and then I look like the bad guy, like I don't.
Well, I mean, there's always that issue. I don't think it's of on that issue, which is legitimate, I don't think, could it be of some value to the court? It could be a rejection or refusal, probably a far more limited value than it usually would, because if we have a sequence of events like we had at the earlier hearings where you must test upon request or you're presumed dirty, you must test upon request or you're presumed dirty, but then we have this kind of breakage where last time the court extended it to him, they didn't think it's necessary. The court then, they didn't request it today either, the court 3 times extended it to them. If we're gonna keep on this drug issue as to it being a current concern, and them asking the court to make findings on it. So if you rejected it, I'm not saying it would be totally irrelevant, but I don't think it would have anywhere near the impact it would if we were still on that structure of regular testing or random testing, and if you refuse, you're presumed dirty. And again, why would it be inappropriate for the court to make that kind of finding? Because number one, there's a breakage in this testing. There was no renewed testing. And 2, they're not really requesting it and yet still indicating drug usage may be a concern without overtly requesting a test despite it being offered. So if you want to take some time, so it is, I understand the damned either way thing, and I get it. I mean,
I can be clear, Judge.
Okay.
I tried to explain to your honor.
I know.
Exactly where we're coming from. I can tell you that I think my client would be amenable of saying, we're not standing here telling you because we couldn't. There's not enough interaction between Mario and Ms. Hurd, and Mario and Ms. Hurd and the child to go, I know for a fact something's going on, Judge. He's very
Can you please just request the test and shut up?
limited exposure. But if you asked us, as we sat here today, based on what we observed, not what we observed 2 weeks ago,
Okay.
but today, if Ms. Hurd's willing to take a drug test, I would love to see her take
Okay.
a drug test. Right? And if she's clean, she's clean, and I will say it was nerves, and it's no harm, no foul, and that would be our position, because nobody's saying we know for a fact.
And that's why, yeah, and that's why I kind of want to spend some time with this, because the stakes are high. It would not be no harm, no foul. It would be a negative finding against one party or the other, either negative against her for obvious reasons, it would indicate a return to narcotics use, and negative against him, it would be viewed as either a false allegation or an allegation that was meant to harass or bedevil and didn't have sufficient basis in fact. So, and I think weighing and balances that is all of that putting into the blender and more is what part of why you guys kind of want to be circumspect with this, and I get it. So why don't we just wait on it and see if there's the necessity of an overt request later, and then we'll move on to
No.
other concerns,
Demand it now.
current concerns, and then if this becomes necessary later, we'll spend energy on it at that time. I guess would be the most fair result for either party. Okay.
With the understanding of what your honor just said, if that's your preference, that's what we'll do.
Okay.
So, we were talking about trust, we kind of moved through that, we were speaking about, the drug issue, I gave you a chance to explain, and that was really the point there, Judge, the testimony. I hope you
Sure,
understood.
sure.
You had the question, so I wanted to make sure you answered it. So, we also talked about, or you talked about concerns over, and I don't want to put words in your mouth, overloading Aslan. Do you recall that testimony?
Yes.
The judge has the questions. So, and I want to take you to something that's already in evidence. Again, this is at, or I believe it's 22, is that correct? 12, I'm sorry, I'm completely wrong, headed to 12. I'll take you to the exhibit, I'm going to ask you some foundation questions about it, though it is already, as I said, in evidence. So, in addition to feeling, Mr. Perry Mario, in addition to feeling that, perhaps during the course of your relationship, that Ms. Hurd, overloaded or overprogrammed Aslan's life. Wasn't it the case that even when she didn't have legal or physical custody of Aslan, that she took to signing the child up for a myriad of programs?
Yes.
Okay, and if I turn you to Exhibit 12 there, is this in fact the printout already in evidence and the listing of these myriad of programs that Ms. Hurd signed the child up for while the court's order was sole physical and sole legal custody to you?
Yes.
Okay, and if you can just scroll through those for me, and I think what you'll see obviously are the types of programs. And then I believe it also shows under each one the dates and times of each program. Do you see that?
Yes.
Okay, so you see the first one there would be this HPAC Penguins. And there she signs despite not having any legal custody or physical custody rights at the time, the child up for Monday, Tuesday, Wednesday, and Thursday from 5:30 to 5:45.
Yes.
And then the next one there, you see again, this ballet and tap. And this is at 9:30 a.m. to 10:15 on Mondays, correct?
Yes.
And then we get into gymnastics on Wednesday evenings, correct?
Yes.
Lyrical ballet, Wednesday evenings, 4:30 to 5:15. And then we move on again with lyrical ballet. And I think maybe what these are is obviously the next sessions of each, but, you know, this listing of, let's say, 10 or 12 activities, 15 activities over a period of time, all occurring during a period of time when the court has already ruled sole legal, sole physical custody to you as a temporary order.
Yes.
None of these were done in conjunction with you, correct?
No.
None of these were done with any notice to you?
No.
Okay.
This was enrollments which occurred after you agreed to lift the supervision and there was some,
No, Judge.
oh, it's earlier, right?
Earlier, this is
Right, sure.
when she's operating under sole legal, sole
Right.
physical.
Right, okay.
You haven't even had a trial yet.
Right.
And in fact, if you look at the top, the very first page, Mario, I'll take you to, actually, it's plaintiff's 2846. You see that?
Yes.
Okay, now this is an email from Kimberly to you. You see that?
Yes.
And that, the date of that is May 12th, 2022.
Yes.
So that's 3 months before the trial approximately.
Yes.
Okay, and that 3 months before the trial, again, the operative order, sole legal, sole physical to you, correct?
Yes.
And this, if I'm looking at this correctly, this appears to be her emailing you, telling you she had signed the child up for all these activities, and that if you couldn't arrange for Aslan to attend, then she would take her to every single activity, despite the court's order that she was prohibited from doing so, correct?
Correct.
Then you also see that, well, I'll leave that there. I'll leave it there, we'll come back.
What number was that?
That's Exhibit 12.
Oh, thank you.
I'm fine.
Wait.
That's my
Leather
exhibit.
was in 12?
My Exhibit 12 is an email, and then
Right.
behind the email is a series of,
Okay, so we're, okay, okay.
So when you were discussing with the court some of your concerns about her co-parenting, and feeling that you were being, or she hasn't, I'm putting words in your mouth, but I'm trying to summarize. Her way or the highway, what are the other words used to describe the way that you felt that she parented,
You're doing it wrong. My way works.
right? Were these the kinds of things you're talking about, sort of like, I'm gonna sign the child up for a myriad of programs without consulting with you when I have every reason to know I don't even have legal or physical custody rights at the time?
Yes.
Okay. So, those are the three factors that I think you discussed with the defendant in her examination of you. I want to talk a little bit about, we covered this topic with your mom, if you recall, when she was testifying a little bit. Do you remember the incident that resulted in police placing her under a mental health hold? Do you recall that?
Yes.
Okay. I don't wanna belabor the point, cause I know the court heard about it, and certainly it is, you know, in that same timeframe, 2-3 years ago. But that incident in and of itself, was it isolated, or in your experience with Ms. Hurd, was emotional volatility like that something that was sort of a hallmark of your interactions with her?
Yes.
How so?
Just conversations, and she'd fly out to handle sometimes. You know, it's just like, you don't know what you're doing, and then just go off, and then she would tell me that, oh, I'm so depressed, or this, that, and the other, and, you know.
I know it's not comfortable to testify, Mr. Ari, and I know that it's common for us to say things like this, that, and the other, but I think for the court's purposes, we're gonna have to get a little bit more detail. So with some latitude from the court, I'm gonna ask you some more detailed questions. Let's start with the incident that Mom talked about. Take me through, to the best of your recollection, that day, you know, what occurred?
I mean, the March 2021.
No, Judge, I apologize. This is,
Okay.
we spoke, I apologize,
No problem.
Your Honor, we spoke about the incident, I misspoke. It was with Ms. Hurd's friend who was a nurse, and we just, Yvonne.
Right, and that month and year again was,
It is October of 2020.
very good. So it's a
So-
little earlier than the
It is.
house invasion.
It is
alleged
about 5
house
months or
invasion.
so, about 5
Okay.
months, yeah.
Okay, very good.
So, and I'm that's Yes. So it's actually already admitted, our Exhibit 1, if we need to go there for reference. And really, truly, Exhibit 1 is already in evidence, but it's just an incident report. But what I'm asking for is your recollection of what actually occurred that day. Because so I'm gonna give you an opportunity. What occurred that day?
I was at Carrie's work visiting her. Kimberly walked into the bar with Aslan in hand, started yelling.
Carrie is 6'1", is this correct?
Yes, sir.
Oh, okay, I just wanna make sure it wasn't, okay. Very good.
And we went outside. Kimberly started getting upset and walking really fast abruptly through the parking lot, which was empty because it's a Lowe's shopping center and Lowe's was closed.
Okay.
Started walking towards Boulder Highway with Aslan in her hand. I grabbed her. I stopped her. I didn't tackle her, but laid her down on the ground, called 911. Carrie then proceeded to come outside, and she grabbed Aslan, took Aslan back to her car, and then she was saying that Kimberly was saying that she wanted to.
Victoria, I hope you're getting ready for work, because you're in trouble when you get to work. You're in trouble. Make that double. Oh, Victoria, I hope you have a good day. Try not to think about it. Put it out of your mind.
End it and walk into Boulder Highway,
End it, what do you mean end it?
commit suicide
Okay.
Withholding Ashland?
while she was holding Aslan.
Now, Mario, the reason that I wanted to pinpoint on this is because clearly, absent the last statement you made, nobody would think that law enforcement would place somebody on a mental health hold for having an argument in a parking lot, right? So, to your understanding, how did law enforcement assess, or was this a voluntary statement that she made to law enforcement about the desire to self-harm?
I believe she made the statement to the law enforcement officer, and they also took my information, my story down.
And you advised them that you had heard her say the same thing?
Yes.
Okay. And is your understanding that based upon that incident, that she was ultimately placed on a mental health hold for a period of time?
Yes, illegal 2000.
Okay. Are those the kinds of behaviors that gives you some circumspection about Ms. Hurd's ability to consistently parent?
Yes.
Okay. Does that mean that she's not capable of parenting for periods of time?
No.
Does that mean that she can't be a healthy, productive parent for certain stretches of time and that, right? Does that mean that?
No.
Does it mean she doesn't love Aslan?
No.
Does your lack of trust in her because of the myriad of incidents we've discussed mean that she doesn't love her daughter?
No.
I mean, she's not committed to her daughter in as much as she can be?
No.
Well, we're on that topic, I may as well, before I forget, I'm gonna ask a question that I always insist on, whether, if the parties remember it or not, remember to ask or not. One which we could probably dispense with, the first one, to rate the other parent on a scale of 1 to 10, but maybe it's more important to ask each party 3 positive parenting observations they have about the other, and or if they can only come up with 1 or 2, then 1 or 2, but see what they have to say. It can't be something non-negative like, well, they're not a bank robber or something like that, which sometimes, or they don't beat the child, you know, that type of thing. So if you want to take that opportunity, and then Kimberly will be asked the same later, can you
Sure.
observe 3 positive traits? If you can only come up with 1 or 2, just whatever you can come up with. I understand you've indicated all the concerns and hesitancies you have, but against that backdrop, just answer it the best you can, please. Go ahead.
Do you understand the court?
Yeah.
He's looking for, if you can come up with a list of 3 aspects of her personality, of her character, etc., that you look at and you find to be admirable qualities in a parent.
Because the reason is because the court has to make a lot of findings, some having to do with cooperation. And cooperation or working effectively together is also based on respecting the other side as a parent. And respecting the other side as a parent, integral to that is being able to separate out some clearly positive points from the parade of horrors that we want to present in court, that each side may want to present in court. So, just do the best you can, and you understand I'm going to ask you the same. Now, you have the advantage of being able to prepare for your answer. He doesn't. So in fairness, if he wants to punt this to a little later, he has that right, but you're both going to answer eventually. Would you like him to, since she has, in fairness, since she has a lot of time to reflect, do you want him to reflect on it?
I mean, I have to believe, knowing this man,
Okay.
knowing the fact that he had a child with her and lived with her for as long as
Sure.
he did, that there are qualities about her that he knows to be admirable.
Perfect.
And that he can
Okay.
articulate a couple of
Perfect,
those
then we'll
for her.
proceed now, please.
I mean, I know she does love Aslan. She does clean good. That's one of her trait. I'll give her that.
Let's expand on that, because it has a propensity to sound away, and I don't think you meant it that way. But if you did, I'm gonna give you an opportunity to continue down that path.
You mean hygienist to the child, or scrubbing
How do you
the
mean? Do you mean-
I
tub and
mean, like
sink, you know, I mean,
cleaning the house.
Well,
She was, okay, and in so doing, you're saying
Hygiene's important.
there's a diligence to that, there's a dedication to that?
Yeah.
Okay, and you find that to be admirable?
Yes.
So is there a work ethic to that?
Yes.
Yeah, okay, all right, so you know she loves your daughter, right?
Right.
You know that she certainly has demonstrated ability at home to be diligent, to clean in a way that you found to be, show a work ethic and a dedication, right?
Yes.
Okay, well, one thing that I'd ask you about is, I mean, I think, has she embraced the fact that you guys had a special needs child to the extent that she could? Meaning, has she leaned in and tried to, in your experience, understand what's going on with Aslan?
Yes.
And do you think that is an admirable quality?
Yes.
Okay.
Leading, he was supposed to figure out his own.
Keep going, but that's what.
Thank you very much, and you can explore this with him as well.
Because I'm,
You'll be able to ask him this, you can explore these
you can
answers.
answer for me too.
We probably wanna, we probably wanna wait till your testimony for this question, unless we wanna take it out of sequence. Speaking of taking things out of sequence, if Carrie's gonna testify, then that should be soon, so we don't have to keep dragging her back, cause we tried to accommodate the other witnesses.
If you wanna if we wanna do that, maybe it was a nice segue, Judge, to the 3 things.
Okay.
Perhaps maybe let's take a quick recess.
Sounds like a plan.
We can run
Let's
to
take
get
10.
her, and we'll get,
Okay.
if you want, do you plan to call Carrie? Is that what you'd like to do? I think Judge is saying.
No, but she has a psychology degree. All right. We're going to end on that note. We are at part 15. So we really only have a little bit to go, guys. Actually, this is only 2 minutes long, so I'm going to play the last minute.
saying if you wanna call her, let's call her now rather than have her come back. She's
Right.
been here now for 3 days.
We've spoken a lot about her. We even spoke about her as to certain incidents and her involvement that we're asking the court to make findings from. So in fairness, if she wants to question her, or if he wants to bolster his case by questioning her, because she's a caregiver, obviously, on some level, obviously, she lives in the home, right?
Sure.
And with his work schedule, she's probably
I don't know.
she's more involved than him, maybe even.
I have no idea.
She can do the-
No idea.
she can, you know, get the
It's
child to school, for
probably an
example.
important witness.
I don't disagree. If you're intending to call her, Ms. Hurd, are you?
Right now, I wasn't prepared.
Okay,
I would like to try to be more prepared. I try to be prepared every
Okay.
time, and I don't seem to.
All right, can we take that 5-minute recess, Judge?
Yeah.
And then either we'll continue with Ms.
We'll make it
Bakari, or
10.
we'll get this,
yeah, we'll be back at 4, okay,
we were discussing.
okay.
I
All right, guys. We made it. We made it. We don't have much more to go. Happy Friday. Happy birthday, MYCO. Thank you for coming out today, guys. I'm going to set up OJ in just a minute. Well, so hold on. This is one stream. So these, these next 5, 6 will be the next stream tomorrow. And then the next day. And then we're done. These 2 will be, I can do all these 3. And that will be the end. So we'll make it to November 2024. And then we'll find out if it's over or we have to wait for another video to come out. This is just the evidentiary hearing. So it's not the permanent trial. And I can't get to the 4 videos that are hidden. I tried. Thank you so much for coming out. I will see you in OJ in just a few minutes. Bye, guys.
Got this life that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes mirror sky so blue. In her jokes, there's a truth so true. With extreme, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor, dark and twisted charm. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray.